Okay, good morning, good afternoon, and good evening to everybody, wherever you are in the world. Thank you all for joining us today, and we're very happy to see so much interest from all around the world in today's conversation. My name is Simon Adams. I'm the Executive Director of the Global Center for the Responsibility to Protect. And let me begin by thanking our co-hosts of today's event, the Permanent Missions of Australia, Germany, Switzerland, and Uruguay. And the last time that we came together to co-host a conference on the role of investigative mechanisms in atrocity prevention was in November 2018 in Geneva. And today, even though circumstances are obviously very, very different, we want to unpack how investigative mechanisms mandated by the Human Rights Council can systematically apply an atrocity lens to their fact-finding and to their investigations. In addition, in the 2 years since our last discussion, we've seen the establishment of several new investigative mechanisms, including for Venezuela and for Libya. We've also seen the HRC renew and sometimes strengthen the mandates of existing mechanisms in South Sudan, in Burundi, Syria, and Yemen. These investigative mechanisms, whether we refer to them as COIs or FFMs or groups of eminent experts, are an important and I would say crucial tool for upholding our collective responsibility to protect. By applying an atrocity lens, they can broaden our understanding of patterns of behavior that enable the commission of genocide, war crimes, and crimes against humanity. And they can also contribute to accountability and the prevention of atrocities by, of course, breaking that cycle of impunity, which is so important for perpetrators. So we hope to examine these and many other issues today with our esteemed panel of experts. Who come from some present investigative bodies and some past investigative bodies as well. But just a couple of very quick housekeeping items before we begin. This event is being recorded and it's being uploaded to our website and to our YouTube channel. Throughout the event, if you're out there, please interact with us on Twitter by tagging @GCR2P or using the hashtag R2P15. I'd now like to introduce our 4 very esteemed panelists. First of all, we have Mr. Marzuki Darusman, the former chair of the Independent International Fact-Finding Mission on Myanmar. He also served as Special Rapporteur on the situation of human rights in the DPRK and a member of the Commission of Inquiry on Human Rights in North Korea. We've also got Ms. Yasmin Sooka. She's currently chair of the UN Commission for Human Rights in South Sudan. She previously served on the Truth and Reconciliation Commissions for Sierra Leone and for South Africa, and as a member of the panel of experts on accountability for war crimes in Sri Lanka. We've got Ms. Marta Valiñas. She's the chair of the Independent International Fact-Finding Mission on Venezuela. She's previously worked in one of the investigative teams at the Office of the Prosecutor of the ICC, as well as for the OSCE mission to Bosnia and Herzegovina. And last but not least, Ms. Laurence André, who's a member of the COI Burundi Secretariat. She has been part of the OHCHR since 2009 and previously worked with the COI on Eritrea, as well as in the DRC and Southeast Asia. So as you can see, lots of experience, lots of a background in these very important issues and lots of practical involvement in these investigative mechanisms for better and for worse. So before we get to that and before we really go deep into our discussion with the panelists, it's also my great honor to first give the floor to our co-host, His Excellency, Mr. Félix Baumann, the Deputy Permanent Representative of Switzerland. Ambassador Baumann, you have the floor.
Well, Dr. Adams, dear Simon, Excellencies, ladies and gentlemen, dear colleagues, let me first of all thank the Global Center on the Responsibility to Protect for its initiative in organizing today's event. and especially also for inviting to deliver some welcoming remarks this afternoon. Prevention is a central issue here in Geneva, and it is very dear to Switzerland. Advancing the respect, promotion, and protection of human rights is at the core of upstream prevention work, and we are continuously working at strengthening the contribution of the Geneva-based human rights institutions in this regard. The Human Rights Council recently passed a resolution on this topic, which we hope will enhance the contribution of the Human Rights Council to the prevention of human rights violations. Switzerland has been active over the years in advancing prevention work, including on the recurrence of violations through various angles. By promoting the twin resolutions on the peace-building architecture, in advancing transitional justice, in promoting the first ever panel discussion on the responsibility to protect to take place next year. Switzerland is also a strong supporter of accountability mechanisms when the situation on the ground warrants it. But what does it mean concretely to apply an atrocity prevention lens to HRC-mandated investigative mechanisms? HRC accountability mechanisms are established to address already ongoing violations and abuses of human rights, and in situations of armed conflicts, violations of international humanitarian law. In most cases, atrocity crimes have already occurred when the mechanisms are established. These mechanisms translate the reaction of the international community to an unfolding situation that has already had a heavy toll in human lives. But they are also meant to contribute to bring ongoing violations to halt and to prevent further violations from occurring. The mechanisms may vary in terms of labeling and the specificities of their mandates. Overall, they are called upon to do similar things, such as investigate, establish facts, identify perpetrators, without accountability as a central, but not sole objective. Equally important, once violations are qualified, it becomes more difficult for member states, as well as the general public, to look away from the plight of the victims. The findings should prompt diplomatic action at the bilateral and multilateral level. They should help human rights defenders and peace builders working in and on the affected contexts to advance their causes. So how can we help creating the best conditions for the execution of these mandates and for their products to help those who want to contribute to halt and prevent atrocities? While we know only too well that this flows from perceptions and results from the negotiations at the HRC, to what extent does the labeling of an investigative body really matter? Does it affect the work to be done? What do we need as states to be attentive to when establishing accountability mechanisms in order to facilitate the work to be done? As mentioned, we consider essential that there is also an attempt to prevent future violations, even in an ongoing situation. What are the main challenges to this? Which elements of a mandate are indispensable for looking specifically at atrocity risks and should be systematically included when establishing an investigative body? We are more than aware of some of the political sensitivities around the UN's framework of analysis for atrocity crimes, and yet consider it to be an indispensable tool to understand the nature of certain situations. Shouldn't its use be considered as a standard operating procedure by all accountability mechanisms, be it explicitly or implicitly? In our view, applying an atrocity lens also helps in identifying root causes of violations, violence, and conflict. Would such work be facilitated if mechanisms were to be established for more than just 1 year? So, ladies and gentlemen, dear colleagues, these are just a few questions for consideration. I will stop here, and I would like to thank you once again for your initiative and for having me at the onset of the event. Thank you for your attention, and I wish to all of you, to all of us, fruitful discussions this afternoon. Thank you so much.
Thank you very much for that, Your Excellency. And Switzerland has obviously been such an important ally in all of this work. And I would now like to give the floor to the Deputy Permanent Representative of Uruguay, Ms. Maria Alejandra Costa Prieto, who's another long-term friend of the Global Center. You have the floor, Ambassador. No? Yes. Over to you. I think you're still on mute there. There we go.
There we go. Thank you, Simon. It's good to see you. And you're not improving your Spanish. You should work on that, Simon. Huh? All right, well, good morning and afternoon to everyone. I am happy to be part of the group of countries that are co-sponsoring this event. And of course, I thank the Global Center for the responsibility to protect for once again putting together a magnificent panel, which I am looking forward to hearing. After Ambassador Bauman's opening remarks, and in order not to repeat what he has already mentioned, I thought that during these few minutes, I could share with you some thoughts that we've been discussing, especially these last few days. As it usually happens in our field, we tend to forget somehow about the half full part of the glass. And so we tend to forget how far the concept of prevention actually has come, how openly we talk about its importance today. Not so long ago, and remember we are talking about international times, which are not fast in this area, to say something about the responsibility of the international community to address a situation and as Pillar 2 of R2P says, to encourage and assist individual states in meeting their responsibility to protect, were almost considered worldwide as an intervention in domestic affairs. Of course, we cannot say that we've reached a consensus on the concept of prevention, and the vote of the resolution that Ambassador Baumann just mentioned, the contribution of the Human Rights Council to the prevention of human rights violations, proves that. But we still should keep in mind that only 3 members of the Human Rights Council vote against it. It is a compromise that Uruguay has to work with other states in finding ways to ensure that the international community keeps strengthening the role of the Human Rights Council in this matter. So we believe that there is an established, strong, and solid concept that the Human Rights Council's mechanisms and procedures, and may I say, especially thematic special procedures mandate holders, are the eyes of the system when it comes to detect and identify risk factors to what later can become a deteriorating human rights situation. Uruguay, my country, believes that the HRC's mechanism should be used in a rational, progressive, and incremental way. We think this is the only way to ensure we use the human rights system wisely, but also the only way to avoid the possibility that the mechanisms are accused of politicization. In that rational, progressive, and incremental way, which I have to tell you, I had to learn it by heart because I always forget one of the 3 things. There are situations that require, of course, the establishment of investigative mechanisms, and a clear, strong mandate is as important as making sure that the atrocity lens is duly included in it. This is a lens that will narrow the possibilities of atrocity crimes from developing. I tried to find other ways to say it, but I could not put it clearer than my friend Elisabeth Bramendorfer did in her talking point for this event. If given the chance, investigative mechanism can play a key role in prevention and non-recurrence of atrocities by identifying existing structural and hybrid risk factors of atrocity crimes, in addition to investigating past ones, which bear the risk of escalating further, period. That's it, and it's true. And the risk factors and indicators developed and described in the UN framework of analysis for atrocity crimes are the, if I make the expression, cleaning clothes to that lens. Here's where I somehow go back to where I began. Applying an atrocity lens to situations where investigative mechanisms are established is prevention. Special procedures may be the tool to prevent systematic human rights violation. We do believe that investigative mechanism can be the tool to prevent atrocity crimes. And again, as I said, even if there's still a long way to go to make the atrocity lens a regular and common element in COI's or FFM's mandates, the road we think is already paved. So I'm looking forward to listen to all the panelists, and I do thank you, Simon, and the Center again for organizing and for letting us be part of this. Thank you.
Thank you so much for that. And thank you very much again to Switzerland and to Uruguay, who have been such great partners around these issues for so long. It's now my pleasure to open up the conversation with our esteemed panelists. So I'm going to begin with Yasmin, who of course, as I mentioned previously, is chair of the Commission on Human Rights in South Sudan. So Yasmin, the mandate of the COHR is considered to be one of the strongest that's been authorized by the HRC so far. So based on your experience of that mechanism, which elements do you think are sort of indispensable when looking at atrocity risks and should potentially be included when establishing any kind of similar investigative body in another country context? Or do you think it's all just South Sudan specific?
No, thank you very much, Simon, and thank you to the Center for inviting me to participate in this discussion. The mandate of the Commission on Human Rights for South Sudan actually has, 4 elements. Firstly, the classic human rights monitoring mandate, and then secondly, a fact-finding mandate which looks at determining the facts and circumstances of alleged violations and abuses. But the third one, I think, is the one that takes it really into the level of what we call new generation investigative mechanisms, and that is the collection and preservation of evidence and to clarify responsibility for alleged gross violations and abuses of human rights, but with the addition and related crimes, including sexual and gender-based violence and ethnic violence, and of course with a qualification with a view to ending impunity and to providing accountability. And then, of course, there's a fourth element, which is a transitional justice mandate, which we have interpreted in terms of the Joannet framework on the principles to combat impunity. And within that rubric, the notion of the 4 elements, the right to truth, the right to justice, the right to reparations, and of course, the guarantee of non-recurrence or prevention, which has really allowed us also to look at the question of the structural dimensions of the conflict. Now, I think what's important about the mandate of the Commission on South Sudan is that we're not only looking at the question of state accountability, but we also have taken it over into what I would call the crossover into investigations, looking at individual criminal accountability. And here we've now begun to focus on not only whether the state concerned has violated their international and domestic obligations, but we've also begun to look at the question of individuals who bear command or superior responsibility. And so these investigations have changed somewhat, and they focus on collecting the context and linkage evidence where we make factual determinations on specific incidents and patterns of conduct, which provide really the framework or the basis for the legal qualifications for what we would call atrocity crimes, war crimes, and crimes against humanity. And we've also interpreted our mandate to include collecting evidence in a manner that allows for the classification of crimes in a different way. So not only looking at treaty obligations and serious international crimes, but we've also looked at how these future prosecutions can take place within multiple kinds of proceedings, including trials under universal jurisdiction, also looking at people who may hold dual nationality where they also are citizens of states who have ratified the Rome Statute. And then, of course, we've looked at the possibility one day, if this hybrid mechanism ever gets set up by the African Union, then ultimately our work will go there. Now, I think what's important about the mandate is the recognition that we're not only dealing with past crimes, but we're also looking really to this lens of prevention. And so on that score, what we've begun to do is to look really at the structural drivers of conflict, which have given rise to both past crimes, but also the ongoing conflict. The Commission is also, in terms of dealing with this question of command and superior responsibility, prepared lists and dossiers of persons that we consider to be of interest. But these, of course, unlike Myanmar, we've decided to keep the names of the perpetrators confidential, with a view that one day, when this hybrid court or any other mechanism is set up, this will be handed over to a prosecutor. And I think that when we looked at this lens of prevention and, looking at what we call the structural drivers of conflict, what we've included are the questions of economic crimes, the scramble for political power to access the resources of the state. We've also looked at the question of hate speech and the curtailment of fundamental freedoms, which are often a signal of the potential for atrocity crimes. And, beyond the notion of accountability for serious crimes. So then we've also looked at how do we use the dossiers that we've built up to look at other forms of accountability, going beyond the notion of serious international crimes. And this has really been very interesting, because for the first time we are thinking about dossiers on perpetrators where we could also be using other sanction structures. So Magnitsky laws, for instance, looking at how these have been passed in different countries. Spoiler sanctions is another area where you can actually take somebody out of the process by saying you're a threat to peace. And so using that lens of prevention, I think that's really given us, an important basis to look both at the future, but also to understand what's there in the past, so that you can begin to say, actually, in your engagement with government, that these are the things that need to improve.
Thank you for that, Yasmin, and I'm intrigued to come back maybe at some point and talk to you a little bit more about the AU hybrid mission, which was the hybrid court, which we're still waiting to get set up. But
yeah.
Let's turn now to Marta. Marta, the report of the Independent International Fact-Finding Mission on Venezuela, although it wasn't specifically mandated to include an atrocity lens, it warned that patterns of violations and abuses that were ongoing in Venezuela may amount to crimes against humanity, which was a very important finding. I think changed the way that a lot of people see the crisis in Venezuela. So at what point during the fact-finding mission did you decide to analyze it from a crimes against humanity perspective?
Thank you, Simon, for the question, and also for the invitation to be part of this discussion. Let me start perhaps by recalling that the mandate of our fact-finding mission was to investigate extrajudicial executions, enforced disappearances, arbitrary detentions, and torture and other cruel, inhuman, and degrading treatment, with a view to ensuring full accountability for perpetrators and justice for victims. And I wanted to highlight, the part that I just mentioned, which states with a view to ensuring full accountability for perpetrators. So while an FFM cannot itself ensure accountability per se, we interpreted our mandate, as other FFMs have done, as tasking us to contribute to processes that may hold perpetrators to account. And as I said, we were tasked with contributing to ensuring full accountability for perpetrators. So we understood accountability and justice for victims in its broader sense. And that is why we formulated several recommendations that do not pertain only to criminal justice proceedings. But certainly criminal justice has a very important role in the process of ensuring accountability and in prevention, as you've mentioned. So the 4 types of acts that we were mandated to investigate constitute both human rights violations according to international human rights law, that is binding upon Venezuela, and also international crimes, and more specifically, crimes against humanity, of course, in case they are committed as part of a widespread or systematic attack against the civilian population. So with this in mind, from the outset, our team investigated the alleged acts, taking into account the definitions and the prohibitions of such acts, both under international human rights law and under international criminal law. We also decided that the team would review a larger amount of alleged violations and in that way identify patterns and from those identify cases to be investigated more in depth, cases that would be illustrative of those patterns. So this on the one hand allowed us to select and prioritize cases that we knew were not isolated, but also it allowed us to collect detailed information about those specific cases, and those are the ones we document in our report. Given all of this, the analysis of whether the acts that our team investigated and that are documented in our report were committed as part of a widespread or systematic attack against the civilian population and pursuant to state policies. Of course, this analysis could only be properly done towards the end of the period that we were given to conduct our investigations. While we had a working hypothesis since early on, as I mentioned, that the alleged violations could potentially constitute crimes against humanity, besides human rights violations, engaging state responsibility, we planned our investigations under that hypothesis as well. And under the possibility that we may be able to gather information that would indeed point to not only state responsibility, but also individual criminal responsibility. So we planned our investigations under these hypotheses, but indeed we were only ready to conclude and to share our conclusions publicly that we had reasonable grounds to believe that crimes against humanity had been committed once, of course, we could analyze all the information that our team gathered.
Thank you for that, Marta. Again, lots there. I think we should come back to, and if we get a chance, dig into a little bit deeper. But let me turn to Marzuki, who of course is the former chair of the fact-finding mission on Myanmar. 2 things. One is that information from the report of the FFM on Myanmar was used in bringing a case under the Genocide Convention against Myanmar to the International Court of Justice. That case, of course, led by the Gambia. So I'd be interested in your response to that, but also to kind of mention that in some ways this was an exception. And so my question really is, has the establishment of these sorts of investigative mechanisms after atrocities have been committed become a way for the international community to absolve itself in some regard for the shame of not acting to prevent these atrocities in the first place? Marzuki, the floor is yours. I think you're on mute there. Marzuki, you're on mute.
Sorry. Thank you, Simon, and thank you for the invitation and the questions. I would probably start with just flagging that that apart from the atrocity lens that was very detailed, laid out by both ambassadors earlier and by yourself, that the FFM, the Myanmar FFM, did use a number of lenses, if you will, and that is that certainly the atrocity lens, but also a lens of the duty of states, and that led us eventually to look at the whole matter in a way that balances out the international community dimension, but also the domestic issue, which goes a long way in a way to ensure that accountability does not stop when the fact-finding mission reports to the Human Rights Council, but goes way beyond that. Another lens that, if you will, I'm finding it somewhat difficult to describe, but this is a lens that drives the fact-finding mission to pursue its mandate in a way that pushes the investigation to the outer limits of possibilities, to the ultimate boundaries, short of transforming the fact-finding mission into a judicial mechanism, which it is not. And therefore, how do you call it? Is that a commitment lens or a compassion lens? You need to really somehow take that into account in a way that describes a fact-finding mission. Now, listening to the co-speakers earlier, I was wondering whether they were talking about the Myanmar fact-finding mission, because there's so many commonalities in a way from what Yasmin was mentioning. Now, the issue of whether the fact-finding mission in a way absolves the international community, the question here was much more graphically put to me. Has it become a cop-out, for the international community to sidestep its responsibilities? Let me say from the outset that I would imagine for all fact-finding missions to establish what was tasked and was mandated finally, and to be able to come out with a definite finding of what actually took place is a tremendous achievement. It's something that will have to be considered as the baseline for further action to be taken, because in the end, accountability goes beyond what a fact-finding mechanism is able to provide, and that is to allow processes to proceed from there on. In the case of Myanmar, the Gambia taking this up with the ICJ, the fact-finding mission itself being instrumental in the establishment of the IIMM, also allowing opening investigations by the office of the ICC prosecutor, and in this case also using what was reported by the FFM, Myanmar FFM, to apply universal jurisdiction in the cases in Argentina, for example. Now, so those are perhaps groundbreaking initiatives, but then again, creating an investigative mechanism or pursuing a case before an international tribunal for a set of facts is perhaps insufficient in terms of protecting the population on the ground from mass atrocities. And therefore, in our recommendations, we didn't zero in on one act of accountability, but proposed that a system of accountability be put in place. And this covers a whole range of issues such as, which goes to the heart of the matter of accountability, and that is ultimately transforming the political culture of that country, which has, in a way, caused these atrocities to take place in the first place, in the first instance, but not in a way that absolves, because of the system, it absolves individual culpability. So the system of accountability would perhaps cover security sector reforms of the military, the reform of the domestic justice sector, and related issues. So answering your question, Simon, I don't think that the establishment of a fact-finding mission, including the fact-finding mission of Myanmar, which may have been placed at quite a high bar in terms of its findings, including what Yasmin has mentioned earlier, the fact that we came out not only mentioning the responsibilities of individual functions, but also names, so that the credibility of the fact-finding mission is pushed to the limit. So just to close my statement, the establishment of fact-finding missions does not automatically, and that does not lead to a absolving of absolution of the international community, but it's perhaps the beginning of the real work to be done.
Yes, indeed. Thank you for that, Marzuki. And last but not least, I'd like to ask Ms. Laurence André. Laurence, you're on the COI on Burundi, and in September of 2019, that COI released a very important, some would say, landmark report that not only looked at the facts and evidence of past atrocities, but also identified warning signs for recurrence. And so I guess my question to you is, what was the added value to the COI of utilizing the UN's framework of analysis for atrocity crimes in the case of Burundi?
Thank you for the invitation, and thank you for your question. So ahead of the 2020 elections, the COI, like many other stakeholders who are interested in the situation in Burundi, was worried about the upcoming elections and possible violence taking place and atrocities, because it had been the case in the past elections. So it was important for the COI to come up with a risk factor analysis to be presented to the international community as part of the early warning and prevention approach encouraged by the United Nations system, but also to have such an analysis that would not be considered as a fortune-telling exercise, because even if you do a risk factor analysis, it's still impossible to really predict what will happen, how it will happen, but it's still important to have something. So looking at the UN framework of analysis of atrocity crimes, it appeared like it was the perfect tool for the COI, because it provides an objective and credible and relevant grid to really assess the situation on the ground in Burundi. It provides numerous indicators to be taken into account in order to conduct this analysis. And also some of these indicators are related to elements which are falling a bit beyond strictly human rights investigation. So using this framework allowed the COI to take into account elements very relevant, very important, that would have been maybe overlooked if we had taken a purely or concentrated only on human rights violations. For example, I'm thinking about really the specific structure of the ruling party and its loose league and how it intertwines with the state institution, the ambiguous role of the Truth and Reconciliation Commissions toward the past atrocities and how it is important and relevant for the 2020 elections, or also the reorganization of some of the security forces and like the National Intelligence Services that was taken out of the official security and defense forces to be put under the direct control of the president and outside of any civilian control and exempted of ethnic quotas provided by the Arusha Peace Agreement and the Constitution. So all these elements were taken into account in this risk analysis, and so that was important. I think the second additional value to use this framework was also to allow the COI to have a more dynamic approach to the situation on the ground. The first analysis was provided in the 2019 report that was presented to the Council in September, so several months before the elections, like the first round of elections was in May 2020. But already in March 2020, an updated analysis was presented to the Council during the oral update during the March 2020 session, and it was already showing some sign of worsening of some of the risk factors. In particular, the political intolerance and so an increase in the political violence ahead of the electoral campaign. So this dynamic evolution and the possibility to take into account and to be able to give some trends on the direction that the situation was taken just a few weeks before the elections was an important part also, thanks to the use of this framework analysis. And finally, of course, I think that because of using this framework to have a credible risk analysis, it helped to raise awareness on the possibilities of atrocities being committed in Burundi in the context of the elections. So it draws the attention of the international community and some state members, some states, to pay close attention to the situation on the ground. And at some very sensitive moments during the electoral campaign where massive violence maybe could have taken place, it didn't happen because we know that there were powerful statements made by different actors. Some private initiatives also maybe were undertaken by some members of the international community. The Burundian actors themselves knew they were under close scrutiny also by the international community. So at the end, I think it was part of a preventive approach that was successful in the sense that there were human rights violations during the electoral campaign, but there were no massive violence.
No, I agree with you. I think it was a very important move, and I think it was taken very seriously by the international community, and it provided a different way of looking at the emerging risks in the risk of recurrence as well in Burundi. Marta, to go back to you, your report was very positively received in Geneva. Do you see merit in the FFM trying to officially brief the UN Security Council? And to what extent could this contribute to your objectives of trying to reframe the situation in Venezuela from viewing it purely as a sort of humanitarian crisis to also viewing it, if you like, as a human rights crisis and a potential situation where crimes against humanity are ongoing?
Mm-hmm. Well, yes, it's true. I believe our report was positively received in Geneva and in other quarters around the world, for that matter. And I think that's due to the excellent work done by our team and the sound methodology that we followed in spite of all the practical and logistical challenges we had to face. and due to the solid findings that we were able to reach. And actually the fact that it was well received in the Council, as you know, was also demonstrated by the fact that our mandate was renewed for a 2-year period. Now, as far as the UN in New York is concerned, we have, of course, seen and welcomed very much the reaction of the UN Secretary General, Mr. Antonio Guterres, urging the Venezuelan authorities to take our report very seriously. I believe that, to answer your question, our findings are an important input to various other UN actors. And this includes, of course, the UN Security Council, in the sense that our findings provide important information to be taken into account as the situation in Venezuela is discussed within the UN by different actors within the UN. So while I would assume that members of the Security Council are aware and have read our report, of course we would be very happy if there is interest to provide a briefing on the report to the Council, in particular because this would allow its members to ask us any questions they may have or further clarification. Now, as a technical body, our task was and continues to be now in the second mandate to document human rights violations and crimes occurring in Venezuela. And we have emphasized in every opportunity we had that these are serious human rights violations and international crimes, which are occurring within the context of a complex political, economic, and humanitarian crisis. But as you rightly pointed out, we have always stressed the fact that they should be examined for what they are, the serious violations and crimes that they are, and not be dismissed for either political convenience and that the various actors within and outside of the UN, in our opinion, should not lose sight of the fact that we are talking about serious human rights violations and international crimes whenever they are discussing about the political dimensions of the crisis in the country.
No, thanks for those insights, Marta, and I wholeheartedly agree with you. I'm going to go back to Laurence. The COA on Burundi warned of a possible rapid deterioration of the human rights situation ahead of the 2020 presidential elections, including possible crimes against humanity. They took place. They thankfully took place without massive violence occurring, and a new government is in place. So I guess my question is, so what now for the COI in terms of the patterns of abuses that you saw, that you identified, the risks that you saw coming? Have things substantially improved? Is there still a role for the COI in terms of the situation in Burundi?
Yes, thank you. Yes, indeed, there is a role for the COI on Burundi, maybe now more than ever, because, of course, this risk analysis was so going beyond the sole human rights violations that we had documented, taking into account the world situation, the complexity of the situation. So to recall, the holding of the 2020 elections were in fact the main indicator of the existence of a triggering factor, the risk factor number 8, according to the framework of analysis. But the Commission had found that the 8 common risk factors were present in Burundi before the election. And it conducted also an analysis after the election that was included in its 2020 report presented in September to the Council. And unfortunately, like the 7 other risk factors still remain as of today. And 6 of them remain more or less as the same as before and change. Some are have a structural nature and cannot evolve in the right direction without the government taking some significant measure. if I'm thinking of the lack of independence of the judiciary, which is also impacting the lack of fight against impunity, also the deep economic crisis and the problem of sharing of resources in Burundi. But one of the risk factor has also worsened and deteriorated through the time and even after the election, which is a shrinking of the democratic space and the lack of mitigating factor. So one of the risk factor has improved, which is the existence of a triggering one, but all the other remains the same. And so unfortunately, also the case of Burundi shows a limit of the risk factor analysis, because no later than last Friday, as you may know, the Security Council decided to remove Burundi from its program of work. And so Burundi is no longer under scrutiny of the Security Council. And without that, taking fully into account, I think, the risk factor analysis made by the COI in its last report. So I think the situation on the ground, it's still of concern. Human rights violations are still ongoing. It's still premature for the COI to provide an assessment in if they are increased or decreased, because we're still in the middle of a new investigation. But the international community seems to lose interest in the situation of Burundi, while some of the indicators have not evolved in the right direction. So the COI is still very relevant at this stage. Thank you.
No, I agree with you, Laurence. I mean, I know from our point of view at the Global Center, we've been very concerned about Burundi for a long time. And I think the level of international scrutiny has helped keep things just below boiling point. So I'm very worried that if people aren't watching closely, what happens next. I want to look at the question of access, which I think is so important for all of these kinds of mechanisms. And we try and look at it from two different angles, I guess. The first is to go to Marzuki and to say, in your role as chair of the FFM for Myanmar, how did you deal with the lack of access that the government provided to Rakhine State? And do you have any best practices or lessons learned that should be adopted potentially by other investigative bodies when faced with a government that really is not cooperative in terms of the mandate?
Hold on, let me just unmute. Okay. Thank you, Simon. I think it's a very interesting angle to the conversation. And in the case of Myanmar, of course, the issue of access is a central matter, as the mandate was not recognized by the country, and the fact-finding mission was, of course, as a consequence, barred from entering the country. But then again, there is this debate about a country refusing access to a fact-finding mission, and then holding the fact-finding mission against the fact-finding mission for having a lack of access, and therefore this is something that is not lost to anyone. Now, in a general sense, in the case of Myanmar, had we been able to been given access, it would have been the case that we would not have had a free access, in that sense of being able to look at any part of the country and at any time given full and unfettered access to the country because of the nature of the issue. But the character or the features of what took place was such that we had ample sources of evidence and information from the very people that we would have been able to meet if we had been given access, that we then were able to meet in Bangladesh in the camps. And so from that point, there was no lack of sources of information, and we were able to conduct investigations in a very methodological way that allowed us to eventually then finally make that qualification on what took place, what allegedly took place in the country, and therefore the enormous number of refugees that flowed out because of the atrocities, in the irony of things, made it possible for the fact-finding mission to meet its mandate. The other angle is the role of the social media, which has allowed also the fact-finding mission to access to valuable information, sources of information. In the case of Myanmar, the status of Facebook, for example. Facebook is the media, so the social media in Myanmar, and therefore one advantage that we had was that relating and communicating with Facebook gave us access to all the information that were carried in the postings, including postings by the military themselves. And of course, satellite imagery was another source of information that helped the fact-finding mission to round off its findings in a way that made it possible to reach a level of finding based on reasonable grounds that atrocities took place in a way that was described in the graphically in the report. So to sum up, access is not an obstruction, and no entry is not an obstruction for a fact-finding mission to undertake its mandate.
Thank you for that, Marzuki, and very interesting your comments about social media, because I think we constantly kind of debate in our world whether social media is a blessing or a curse. And I think, you can easily look at the way in which social media was used in Myanmar, and I think this is true of many of the country situations that we're discussing here today, as a place where hate speech takes place, where it can be a forum for incitement. And yet the other side of that question, I think, as you've very correctly kind of identified, is it also provides evidence of what happened and can be a useful tool for determining the patterns that targeting has kind of taken place. I want to continue on this question of access. So I'm going to go to Yasmin here now, because unlike the situation in Myanmar, the government of South Sudan cooperated to a certain extent with the COHR. So how did that facilitate, or how is this facilitating your work, particularly given that the government also played a role in perpetrating those atrocities as well?
Thanks, Simon. I mean, it's a very interesting dynamic because the government of South Sudan, of course, is a co-sponsor of the resolution which established the commission with the Human Rights Council. And of course, to get to that point, you also have African member states, the African Union, all of them to some extent contributing to the notion that South Sudan should support the Commission. And how that's translated, of course, has been into what I call unfettered or really remarkable access, not just to South Sudan, but also to the neighboring countries. And so, you know, the Commission has a ground presence in South Sudan. We have a 17-person secretariat on the ground. And then, of course, we've also been able to benefit from the fact that you have a peacekeeping mission. And so usually when we go into the interior, we kind of hitch rides with the UN system. And that certainly has meant that we've gone to places even the government hasn't been to in South Sudan. And then, of course, because the governments in the region have been supportive, we've also been able to visit all of the refugee camps in both Ethiopia, in Sudan, Darfur. We went to Kenya and, of course, Uganda, which has a massive refugee population. And so you're really able to send your team in there to do the documentation. But what's been very useful is also coming back into Juba and being able to engage in the public consultations with the government. So you're able to say to the government, this is what we picked up on the visit. And, you know, this is what you need to be dealing with. And so what that has opened up for us is an engagement with the government. And usually you have the Minister of Foreign Affairs who convenes all of his team. And, you know, you have quite an exchange with them around the question of both the violations, but also what measures the government has taken to deal with it. Now, granted, you know, the one issue that the government is quite sort of sensitive on is the question of the hybrid court for South Sudan. And, you know, the way in which the Commission's mandate is structured is that one day the evidence that we've collected and preserved will be handed over to a future prosecutor. And of course, this conversation goes right back to the beginning of the Commission's mandate in 2016. And it's really weighed down, I think, by the fact that you've had 2 peace agreements, the recent one revitalized in 2018. But really, this year, I think you can almost write off the fact that the government has not been able to meet the unity government, its obligations in terms of the agreement. And what that does, of course, is that it pushes this question of the hybrid court, which the African Union has responsibility for, further and further away. And of course, in our engagement with both government and the African Union, it's really been interesting when you come back to the kind of things they say, which is, you know, what we need first is peace. And then we can begin to talk about justice. And of course, one should remember that part of the peace agreement, particularly Chapter 5, also has a clause which says that if you're indicted by the prosecutor of the hybrid court, then of course you are barred from taking part in political activity. And so you can almost see the way in which people's minds are working. Let's not get this court set up before we have elections. And I think that lag has also lent itself to the delay in setting up the Commission on Truth, Healing and Reconciliation, and of course the Compensation and Reparations Authority. And this has been very, you know, a very useful element of our engagement with the government, because we've had several workshops, you know, every time we've gone to the region. And this is where we've brought both the government, civil society, and the opposition parties as well. And it was really interesting when we did one last year on transitional justice, because civil society said that it was the first time that they'd actually had an engagement with all the parties to the conflict. And so that was an important initiative. But I think that, you know, the fact that we can see that criminal accountability is shifting further and further away has really compelled the Commission to look creatively at what could be other forums or other mechanisms to begin to use the evidence. And so we've also been in a lot of discussions with the Office of the High Commissioner, as well as with the IIIM, on how do we, you know, create these protocols which give access to people who would ask it, including prosecutors in other, states around the question of universal jurisdiction, but also looking at many other bodies as well where the information can be used. So it's been quite an interesting dynamic, but we look at the transitional justice mandate as a clear frame for the question of prevention. And so from that perspective, what we've been looking at is the question of the management really of diversity, which I think is a huge problem in a country like South Sudan. The fact that the divisions between different armed actors is really based on ethnic and religious differences. And of course, with that, also the question of incredibly high levels of sexual violence, which we've also pointed to in our reports. So it's an interesting dynamic, but the government, of course, is really wanting to move from an item 4 investigation to item 10. And they are saying that, in fact, what they want to see is technical assistance. And so what we said to member states is that you can't just move from one item to another. You should be putting in benchmarks. And the benchmark should really look at how do you improve the situation in South Sudan? And what are the indicators that you can set for the government as indicators that the government is seriously considering its, its own obligations in terms of both its treaty obligations and, of course, domestically as well. So an interesting space and play there.
Yeah, no, fascinating. And remarkable, or maybe not remarkable at all, given that the government and opposition fought a civil war that cost 400,000 lives, that the only thing they seem to agree upon is that the hybrid court cannot be established because, of course, they both sides face possible indictment by any court that would be set up. And strange that we seem to just continually be having this discussion about peace versus justice as well, neglecting the fact that justice can actually contribute to peace. Let me try to ask a question of all of you, and feel free to jump in any particular order after I ask it, which is, when establishing investigative mechanisms, we sometimes get caught up in how to name them. So could you share with us, to what extent does it matter at all whether an investigative body is labeled as a COI or an FFM? Is there any meaning for this in the real world, or is this just another example of a very specific nomenclature that comes out of the UN? I don't know if anybody wants to. This question was given to me by our staff, and I'm interested to see how people will respond.
So maybe I should take a stab at it. The Commission of Inquiry on South Sudan actually started off by the Office of the High Commissioner wanting to set up a team of 3 rapporteurs. And for some reason, the notion of special procedure mandate holders for South Sudan offended the government so much that they went back to the drawing board, and they actually came back and said, well, we'd prefer to have a commission of inquiry on South Sudan. And it was really, I think, when you look at its original mandate, it was a classic human rights mandate, but it was when we and the special advisor on genocide began to report on the fact that we saw indicators present in the environment which could possibly end up with a genocide, that the Commission's mandate then changed to this collection and preservation of evidence. And so I would argue that it's really important to have language in the mandate which allows you to achieve a particular goal. And so from the perspective of the South Sudan mandate, what it's allowed us to do is not only to document human rights violations, but to actually turn these investigations into ones looking at the question of criminal accountability. And it's allowed us to interpret our mandate to really identify the individuals and institutions that we think are responsible. And of course, to really build these perpetrator dossiers, which looked both at the question of the context and linkage evidence, as well as commander and superior responsibility. And we know that the preparation of the dossiers have quite a chilling effect on the government, because what we also found when we've published our report and we've noted that we have designated so many people who were involved in this incident on our list, that suddenly those people get removed from public office. So the government also thinks that it's doing something. So I think it's really about the language and the mandate, and in fact the support that you get. The one thing that doesn't work, and I think this is a challenge for the Human Rights Council, is the need for the annual renewal of a mandate, because unlike the one for Syria, all of us have to start basically over again, and it's really hard to keep your support staff in place. So these are some of the technical issues which I think need to be ironed out.
Yeah, that's a big logistical issue that I think a number of people from these different investigative mechanisms have raised. It also becomes a tool, if you like, for those who would like to stop the investigations going forward, to kind of stall, essentially the stalling payment of staff, and potentially things grind to a halt. That's really fascinating, Yasmin. Does somebody else want to have a crack?
Simon, if I can just
yes, of course, Marzuki.
Continue where Yasmin left off. Fully agree with what she said, including the technical staff. When a fact-finding mission or COI gets extended in its mandate. Now, apart from the importance of language, of course, that is key. It's also the room for the members of the fact-finding mission to interpret the mandate. That is a key issue here, and that allows leeway for the fact-finding mission to define the scope of its mandate in terms of perhaps the temporal aspect. What is the periodization that we will be looking into? That could go like maybe 10, 20, 30 years before the event. And also the geographical scope of the investigation. So that has always been a debating point in the Human Rights Council, that the Myanmar fact-finding mission had gone beyond its mandate on the basis of the language of the mandate. But our rebuttal was that we didn't go beyond our mandate. What we did was to achieve more than expected, because of our interpretation of the mandate. So, calling it a COI or a fact-finding mission may be less of an issue than the language of the mandate, but also the interpretation of the mandate by the members of the. And this is where I think chemistry between the members is imperative. I mean, we had a very, very good staff, had a very good members of the fact-finding mission. It was a dream fact-finding mission.
Hey, Yasmin, you wanted to say something very quickly about that?
Yeah, I think Marzuki is right. I mean, obviously the sort of combination of people needs to work well, but I think it's also about imagination. And so, a new area for us this year had been the question of economic crimes. And of course, the government wanted to know whether or not how we interpreted this to be in our mandate. And we argued that, in fact, that what the economic crimes and corruption were doing was, in fact, limiting the government's ability to deliver on their socioeconomic rights obligations. And in that context, we were also able to say that actually this is a real driver of the conflict, because part of the fighting is about people battling for access to political power so they can have access to the resources of the country, and that's then up for plunder. In addition, of course, we also looked at this question of starvation because, one of the challenges of South Sudan has been the government's perpetual denial of humanitarians to places where refugees and internally displaced populations are. And we said to them, actually now, what you are courting is the fact that this constitutes a war crime and a crime against humanity. And so this has upset them a little this year, but it's really been fascinating just in terms of looking at how can you push the boundaries out further. And I think that's our job, really. It's to push the envelope.
Yeah, the weaponization of hunger, which is, I think, again, we see in a number of situations, conflict situations, but the importance, the theme here, I think, from both Yasmin and you too, Marzuki, is the importance of political support for your mandate as well. Laurence, do you want to get in on this?
So just to my knowledge, in fact, in reality, there is no difference between the FFM and the COI because when you look at the most recent ones, they have the same kind of mandates. Maybe historically there was a difference, I'm not sure, but I think it's really, at the end of the day, a matter of diplomatic negotiation. Somehow, maybe a name is more accepted in a certain circumstances than another. But at the end of the day, like it was said, it's really the content of the mandate and how it is interpreted by the members of this investigative mechanism that matters.
Yeah, no, we sometimes face this from the other side, from people who do human rights advocacy with the Security Council and also with the Human Rights Council, whether it's called an FFM or a COI, sometimes from our perspective is kind of immaterial. My first question is what's most likely to get through and get enough votes to make it become a reality. Marta, do you want to?
Yes, Simon, maybe I'll just add something. I mean, I of course concur that technically and formally I think there is no difference, and in fact that's quite clear if you look at the guidance is issued by OHCHR, for example, which is the same for both types of bodies, and the understanding that the mandates that include a reference to ensuring or contributing to accountability, may and have been indeed interpreted by both FFMs and COIs as, including not just state responsibility and not just the more traditional human rights monitoring type of tasks. So I think that is quite clear from a technical point of view. But I just wanted to add that I do think that, and I agree that it is the mandate and interpretation that counts the most. But it is also true. I mean, I would recognize that, there are also certain messages being sent and that may continue to perpetuate the understanding that there is a certain sequence which can also be associated with a certain ranking between the two types of bodies. And I think it would be actually helpful to clarify this, whether this is coming more from a diplomatic background than a technically grounded discussion. I think it would still be helpful to revisit that. So, for example, you probably know this, that in both Human Rights Council resolutions, the one that created our FFM and the one that extended its mandate recently, the Council decided that it would consider further measures, including the establishment of a commission of inquiry if the situation would continue to deteriorate or if Venezuelan authorities would not meaningfully cooperate. Now, we have had a one-year mandate. We now have a two-year mandate. We have a larger team now. So, where the differences between what an FFM and a COI could be really get diluted, but then you still have this sort of language. And as I said, I just think, it would be helpful to revisit maybe the need to have this different terminology for bodies that are actually in practice rather similar. And you know, having said all of this, I firmly believe that the contribution and the impact of a given FFM or COI will certainly be more contingent on the quality of the work done than its title, for sure.
No, and thank you for that, Marta. And that's a good reminder, and that's a very strong point, I think, for us to kind of end on, because I'm conscious of the time, and I'm conscious of your time that you've all been very generous with. This has been you know, a very insightful and substantive conversation about these mechanisms. And you know, I just want to say, as somebody who works, as I said, in the human rights advocacy kind of side of this, you know, we thank you all so much for what you have done and for what you're doing in terms of not only exposing these crimes, but also putting your finger on the scales of justice and tipping things towards accountability and international justice. I now have to, it's my honor to give the floor to our final co-host, and Mr. Nicholas Burridge from the Permanent Mission of Australia, who's going to make some closing remarks before we wrap up. I think we've got our esteemed Australian friend there. Otherwise, you'll have to put up with my hybrid Australian South African accent for a while longer. Ah, here we go. All right, it's over to you, my friend.
Thank you very much. Firstly, just a few brief remarks. Thank you to the Global Centre for the Responsibility to Protect for hosting this meeting, and Dr. Adams, yourself, for moderating. We are pleased to support this event along with the permanent missions of Switzerland, Uruguay and Germany. Thank you also to the esteemed panelists for their informative presentations today. This session today has been extremely helpful to hear about how to maximise early warning, prevention and accountability outcomes from HRC-mandated mechanisms, in particular investigative mechanisms. The Human Rights Council and its various mechanisms, including commissions of inquiry, fact-finding missions, such as those discussed today, along with the Universal Periodic Review and special procedures, play an essential role in monitoring, reporting and advising on country and thematic human rights issues. They strengthen accountability, advocate for inclusive institution building at the national level, and provide early warning of possible atrocity crimes. During Australia's term on the Human Rights Council, we continue to advocate for atrocity prevention and accountability in country situations, including through supporting relevant country mandates. We were also pleased to support the first R2P thematic resolution in the HRC to encourage a base for pursuing practical linkages between the HRC mechanisms and atrocity prevention. As repeatedly emphasised in the UN Secretary General's annual reports, we must be more effective in translating early warning signals into action through implementable recommendations and quick council responses to reports of deteriorating human rights violations. We can see from today's discussions a role for investigative mechanisms can have in this. I thank you very much.
Thank you for that, Nick. And again, I just really want to emphasize how important these great partners have been for us. Australia, of course, who just spoke, but also Germany, Switzerland, Uruguay, who have been very important for us at the Global Centre, but I think very important in this whole area of accountability and international justice as well. We've unfortunately reached the end of our event today. I want to thank everyone for joining us, and a special thanks, of course, to our 4 wonderful panelists for sharing their expertise, for sharing their experiences. And we'll continue to organize these virtual events and discussions as long as this accursed plague is amongst all of us. So if you're interested, please go to our website, globalr2p.org, to sign up to our mailing list or follow us on Twitter, and there will be more important conversations on issues of justice and human rights to come. So thank you all. Have a good day, evening, midday, wherever you happen to be in the world. We've got several continents represented here on the panel, let alone amongst the people who are watching, and I hope everybody has a good evening. Thank you. Goodbye, everyone.
Thank you. Thank you.